Good morning, everyone. Thank you for tuning in. My name is Changez Khan. I'm a barrister at No5 Chambers. I'm a member here of two teams, the Business and Property Group and also the Employment team. I've chosen to speak about contractual penalties today. They're something of a pet topic of mine, but also I believe that they are going to be a hot topic in the coming weeks and months. The chances are that many of us have had clients call us up recently and explain to us their business woes. They've been telling us about the impact of the recession on their business, and they've been asking us questions such as, what happens if I default on my business loan? There's a clause in there about penalty interest. Will it be enforceable against me? Or perhaps a client has called you up and said, we as a company are tied in to a fixed-term contract of some sort. However, we can no longer afford it. We need to get out. How can we get ourselves out without incurring early termination penalties? Or maybe your client is in a slightly better position. The other party to the contract has defaulted on its obligations, and your client wants to know whether it can enforce a penalty clause against the other party. These are all hard questions, and clients rely on us as their lawyers to provide sound commercial and legal judgment and make difficult calls. I know we're all busy, so I'll get straight to the point. When it comes to contractual penalties, there really is only one question: will the court enforce? And unfortunately, there is no magic test which tells us yes or no on enforceability in every case. Instead, we do, however, have a framework or a set of rules, and I hope that by the end of this webinar, we'll all feel a bit more confident and reassured when advising our clients on these difficult questions about contractual penalties. So, the Bar Code of Conduct requires all barristers to start every webinar with a bad joke. Here's mine, I'll get it out of the way. Where is the worst place to put a penalty? In a contract, of course, and I'll explain. Today, then, we're going to cover the following. And number one, what are contractual penalties? What do they look like? Number two, why have they proven so controversial? Number three, and this is really the meat of today's webinar, when will courts enforce them? Number four, we'll then go on to take 3 case studies, and you as the viewer will be in the position of a VAR referee, and you have to decide whether or not a given clause is a penalty and so unenforceable, or whether it's not a penalty and therefore is valid. I'll then wrap up with some conclusions, and hopefully there'll be a bit of time to take your questions at the end. So what are contractual penalties? What do they look like? They come in all shapes and sizes. The most obvious penalty is in the nature of a fine. So dead easy example, for every day that a construction company delivers a project late, it will pay a fine of £1,000 or £5,000. Another type of penalty could be the forfeit of a deposit. So, for example, if someone has entered into a contract for purchase but then failed to complete, that person might end up forfeiting their deposit. Yet another kind of penalty could be a price adjustment clause. So those of us who are used to dealing with shareholder disputes will know that often there are bad leaver provisions in shareholder agreements. So if a shareholder leaves the company and on his way out does something in breach of contract, then his shares are automatically bought back, not at the market rate, but at some kind of discounted value. In short, any clause which imposes some kind of forfeit or sanction is potentially a contractual penalty. Why do parties use penalties? There are good reasons and bad reasons for including penalty clauses. A good reason is that a clause provides both parties with certainty. So, for example, on the daily fine clause, if the party is late by 5 days, then the formula provided for in the contract is that that party pays 5 times by £1,000. Dead easy, everyone knows where they stand, and if you like, the clause is a shortcut to a damages judgment. It avoids both parties having to engage in risky litigation. A similar kind of clause also helps the party who could be in default, because they then know the limits of their exposure, they can plan and take out insurance cover accordingly. In other cases, penalty clauses are included for less legitimate reasons. Sometimes it's simply a case of one party throwing its weight about and including in its standard terms penal clauses just because it can. So why are penalty clauses controversial? It boils down to one issue. There is a tension between certainty of contract on the one hand and not condoning oppressive behaviour or commercial bullying on the other hand. And I can explain this very simply. On the one hand, courts don't like people who evade their contractual obligations. If you signed up to a contract and it included a clause with a defined sanction and you accepted it fully and freely at the time, then there is no point whinging about it months or years down the line when you fall foul of the clause. Tough. It would not be principled, the courts say, for you to wriggle out of that clause, and it's not fair on the other party, because their certainty of the contract is undermined. Equally, on the other hand, courts don't like to endorse punishment. So if the clause is so draconian and so disproportionate to the breach that it would be unfair to enforce it, then judges won't lend their hand. Judges are fair-minded people, and they want to ensure that parties conduct themselves fairly and that no improper advantage is taken. So, for example, a loan shark will find a judge very reluctant to enforce a rate of interest which is exorbitant. So the real question in all this is, where do courts draw the line? How do courts draw the line? And it's always a balancing act between those two competing factors: certainty of contract on the one hand and preventing oppression on the other. So the law really must start with the case of Dunlop pneumatic and new garage. I'll be frank, no one wants to hear about a 100-year-old case to do with car tyres first thing in the morning, and for that reason I've included a picture of a racing car from 1914, the year of the case, at the Le Mans Grand Prix. This might give you an idea of what a car and what a car tyre used to look like back in the day. And if you look at the back left-hand corner of the picture, you'll see a man with a guitar. I suppose he would have been the live entertainment at Grand Prix in the day. The case itself involved a price maintenance agreement. Very simply, Dunlop, a large manufacturer and supplier of car tyres, dealt with high street garages. It supplied them with tyres. The high street garages signed up to a clause which said, we promise not to sell Dunlop tyres below the official list price. We promise not to undersell. They signed up to a further clause which said, if we breach that, if we do undersell a tyre, we will pay you, Dunlop, £5 per tyre per breach. The case came before the House of Lords. The House of Lords said, well, if you are testing whether this £5 per breach clause is penal or not, there are different angles which you can look at it from. One way of testing it is to ask, is the £5 per breach clause unconscionable or extravagant? Now, a fiver might not sound like much in today's money, but in 1914, £5 was the equivalent, adjusting for inflation, to £600 today. It seems quite a lot, doesn't it? Another way of asking whether the clause is penal is to consider whether it's a one-size-fits-all type clause. So is it £5 per breach regardless of how much they undersold the tyre for? Another question is to ask, does £5 per breach reflect a genuine pre-estimate of Dunlop's loss? So these weren't hard and fast rules, but these were regarded as relevant factors, ways in which you can test whether a particular clause is penal or not. In this case, the House of Lords said the clause was not penal because it was not unconscionable or extravagant. The important thing to take from this case was the phrase genuine pre-estimate of loss. That emerged as something of a popular slogan over the next 100 years. Sorry, I'm just getting some technical messages. Genuine pre-estimate of loss provided something of a ready test for people who were arguing about penal clauses for the next century or so. Lately, we've had a decision from the Supreme Court in two conjoined cases, Makdessi and Parking I. The issue of penal clauses came before the Supreme Court for the first time in a long time, and the court thought it was a good opportunity to revisit Dunlop and the test, so to speak, of genuine pre-estimate of loss. And what they said was, well, let's reinterpret Dunlop. Genuine pre-estimate of the loss was not actually what decided the case in Dunlop's favour. There was no proof that Dunlop actually suffered a loss, a financial loss, each time a tyre was undersold below the list price. What was really happening in Dunlop was that the £5 clause was there to preserve Dunlop's pricing strategy. Underselling tyres cheapened Dunlop's brand name, and the £5 clause was there to deter the cheapening and the undercutting of its price system. Now is time for a new approach to penalty clauses, and this is the test which Lord Neuberger proposed. I'm afraid it's not as snappy or as punchy or as easy to remember as genuine pre-estimate of loss, but it is the current test. The true test is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. Gosh, let's break that down. I believe there are really 4 stages to this test, as follows. Number 1, you identify the primary obligation, that's to say, the obligation which was breached. Number 2, you try and peel back behind that obligation and you look at the underlying interest the innocent party had in having that obligation to it fully performed. Number 3, you identify the so-called penalty, or what the Supreme Court chose to call the secondary obligation. And then number 4, you stand back and you ask yourself, is the legitimate interest in performance broadly in proportion with the penalty? Or are they out of all proportion? So what we will notice, if we are astute, is that it's really stages 2 and 4 of the test where there is some scope for play, and where we can be perhaps slightly creative as lawyers with our arguments. And hopefully I can demonstrate this now by reference to case studies. So let's have a look at the first of our case studies, a price adjustment clause. Let's say someone wants to sell their company and signs up to the usual suite of non-compete covenants, saying that he promises, following the sale, he won't harm the goodwill. So he won't set up in competition with the company he's just sold, he won't poach his old clients, etc. Let's say he then breaches his own non-compete covenants, but in a relatively modest way. On the facts of this case, that action for breach of covenant was settled for a relatively small sum. £500,000 is a lot of money, but in the context of the case, it was a relatively modest sum. However, the sting in the tail for the seller is that there is another clause in the sale contract which says, if you breach your non-compete covenants, there will be a price adjustment. And in this particular case, there was a huge price drop of more than $40 million. Do we think that the price drop, the price adjustment clause, is penal or not? I'll give you a moment to think about it. Well, the answer in this case is that the clause was considered not to be a penalty and was enforceable. The facts come from the Makdessi case itself, and this was the Supreme Court's reasoning. Taking the 4 stages of the method we identified earlier, at stage 1, the primary obligation is not to compete. And stage 2, the buyer's interest in performance of the non-compete is quite simply to preserve the goodwill of the company. Step 3, the secondary obligation, or the penal clause, is the price adjustment, the large price drop. Step 4, we stand back and we ask whether the interest in performing, that's to say, the interest in preserving the goodwill, is out of proportion to the price drop. And in this particular case, the Supreme Court held no, it's not. This is a case where the non-compete clause was of central importance. The negotiation of the price of the company was premised on the seller being a loyal seller. And once you take away the seller's loyalty, the negotiation unravels and the negotiated price is no longer a valid one, and therefore this kind of clause, which asks for a readjustment of the price, is valid. Next case study. A similar kind of clause, not price adjustment, but rent adjustment. A bonus point for anyone who can identify the lady on the slide. Yes, it's Vivienne Westwood, because the facts of this next case come from litigation involving a Vivienne Westwood store. It took about a commercial lease for one of its shops. The rent was expressed in a curious way. The landlord said to the tenant, the standard rent is £110,000 a year. However, if you are a good tenant and you abide by your covenants, the rent we will accept is a reduced rent of £90,000 a year. However, if you are a bad tenant and you breach your covenants, if you fail to pay your rent on time, then the rent will revert to £110,000, both prospectively going forwards and retrospectively from the beginning of the lease. What do we think? Is that kind of rent adjustment clause penal or not? Well, the answer, according to the High Court and Mr. Justice Fancourt, is that it was penal and therefore not enforceable. And this was his reasoning. Step 1. The tenant's primary obligation was to pay rent on time, and it failed to do that. Step 2. The landlord's legitimate interest in that clause was to have a good tenant, one who pays promptly. Step 3. The secondary obligation, which was triggered by late payment of the rent, was for rent to be increased both retrospectively and prospectively. And step 4, was that adjustment out of proportion to the landlord's legitimate interest? And here the High Court said yes, it was. And there were a number of factors. First, it said that a retrospective increase is not something which can be justified. It said that a blanket penalty, so for example a reversion to a higher rent, no matter how serious the breach, again suggests it is penal. And then the High Court also said, well, the contract already provides a number of other provisions to compensate the landlord if rent is provided late. There are generous clauses in the lease already about interest in case of late payment. There are generous clauses in the lease about the tenant having to pay the landlord's costs of litigation on an indemnity basis. So why do we need the rent adjustment? In the High Court's view, that adjustment clause went beyond the landlord's legitimate interest. The third and final case study I'll take involves early termination penalties in fixed-term contracts. This is a case which I'm currently advising on, which hasn't yet been decided. The particular case involved a director's service agreement, so a slightly fancier employment contract than usual. The director had written into the agreement a golden parachute clause. The effect was, if you terminate before the end of the fixed term, then you, the company, must pay me a large sum of money equivalent to double my annual salary. What do we think? Penal or not? I will let you know if we get to court, but here are the questions going through the same 4 stages in MacDessie. Number 1, what's the primary obligation? The obligation is the one on the company, the employer, not to terminate prematurely. Number 2, what's the director's legitimate interest in that obligation? Well, the director would say it's preserving his market reputation. Being hired to do a high-profile job and then being dismissed from it prematurely is something of a blotch on your CV, and it harms your career prospects. The director might also argue that he's reliant upon this post to bring stability to his life. If, for example, he's moved from overseas and his family life has also moved with him, then terminating the contract early is incredibly disruptive. Step 3, what's the secondary obligation? So it's 2 years' gross salary. Let's say in this case it was £300,000. And then step 4 is the obligation to pay the penalty for early termination out of all proportion to the director's legitimate interest. It's up for grabs. It's debatable. What does everyone think? Would it make a difference if the director actually landed on his feet and within a short period of being terminated found a new job at the same or even better pay locally? Does it make a difference that the penalty clause provides for a one-size-fits-all penalty, regardless of how early the contract is terminated? Should it be the same payable if the contract was terminated a year early as if the contract was terminated only a week or even a day early? Things to think about. Finally, let's wrap up with some concluding thoughts. Here are my views. There is clearly a shift in the case law since Makdessi, a shift away from the old notion of pre-estimate of loss, and the new focus is on legitimate interest in performance, the innocent party's legitimate interest in performance. And here is where we can be slightly creative as lawyers. If you are having to draft a contractual penalty for your client, my tip would be to have some reference in the contract to what your client's legitimate interest is and what that contractual penalty is seeking to protect and how. Now, you could include something in a preamble. For example, the parties agree that A has a legitimate interest in ensuring that the contract is maintained for a minimum of X years because ... The benefit of doing that is it provides an agreed and contemporaneous record of what the parties were thinking at the time they entered into the contract. It's a way of future-proofing the contract. So if ever the clause is argued about in litigation and a judge and lawyers pore over it, they have there in the contract itself a record, a window into what the parties were thinking at the time. And of course, the date at which you assess whether a penalty is in proportion to the legitimate interest is the date at which the contract is concluded. It is not, to be clear, the date of the breach. So be careful not to be caught out by that, because the breach date is often an important date in contractual disputes, but when looking at penal clauses, you're looking at the date of the contract, not the breach. The other point to take from the case law, in my view, is that there are no quick fixes. It's very tempting as lawyers to argue by reference to previous cases and precedents, as we like to say. And the hackneyed phrase is, well, this case is on all fours with a previously decided case. In the world of penalty clauses, no two cases are identical. And I hope the contrast between the facts of Makdessi and the price adjustment clause, and on the other hand, the facts of the Vivian Westwood case and the rent adjustment clause illustrate that. You have to look not just at the penal clause, but also the contract globally, other provisions, and whether they adequately protect the innocent party's legitimate interest on their own. Finally, let's talk about Plan B. A good lawyer always has a Plan B up his sleeve for his client. So if you're acting for a claimant and you can't enforce the clause because you think it might be a penalty, then you should always plead an alternative case. You can still sue for your actual loss. Of course, it's harder. You've got to prove causation. You've got to prove quantum. You've probably got to incur a bit of money in litigation and in experts' fees. But it's potentially a valuable alternative case, and it should not be ignored lightly. And now put the boot on the other foot. What if you're for a defendant and you want to challenge a clause because you consider it's penal and shouldn't be enforced against you, but your prospects are a bit iffy? Are there any other grounds on which you might want to challenge the clause? If you're a consumer, the good news is you can challenge the fairness of the clause under the Consumer Rights Act 2015, and regardless of whether you're a consumer or not, you can always, as a fallback, have resort to the equitable doctrines of unconscionable bargain or economic duress. Although they come with a health warning, they are exceptional grounds for challenging a clause or a contract. If you find yourself in that territory, a recent useful decision from the High Court is Adair Finance and Yellowstone, and I've included the reference there at the bottom of the slide. Well, thank you very much for your attention. I'm happy to take some questions, and I'll start with one which was emailed in advance. So I have a question here about penalty interest in loan agreements, and whether it would be penal for a loan agreement to require penalty interest both retrospectively and prospectively. Well, the leading case on this is still Lordsvale and Bank of Zambia, and in that case the court held that a penalty interest clause for future, going forwards for the future, is not penal, and that's because the lender has a legitimate interest. The legitimate interest is that once the borrower is known to have defaulted, he is considered from then on as a higher credit risk, and therefore it's commercially justified to charge him a higher rate of interest. So if we apply that logic, in my view, a penalty clause which provides for prospective higher interest would be enforceable, but a clause which provides for retrospective higher interest would be unenforceable, because there you are simply punishing the party. His greater credit risk was known to you only from the date he breached. And again, you have the Vivian Westwood case, which shows you that generally courts don't like retrospective clauses. Another question is to do with, to what extent do courts take into account parties' bargaining power, equality of bargaining power? It's a good question. Courts can take it into account, and the Makdessi case rules that it's legitimate to do so. But the trickier question is, how do you take it into account? So in Makdessi, it was taken into account in order to reinforce the clause and to uphold it as enforceable. Makdessi was a case where both parties were well advised, and the negotiation of the contractual terms had been going back and forth for some 6 months. And the court held, well, two well-advised parties, each of them with expensive lawyers, the negotiation having been conducted at arm's length, Mr. Makdessi went into this clause eyes wide open, and it's not for him to now argue about it as a penal clause. So in that particular case, the fact the parties were of equal bargaining power was in favour of upholding the clause. In the Westwood case, however, the parties were of equal bargaining power, and yet the court still refused to enforce the court. I think the only safe conclusion is that bargaining power is a factor, but it's not going to be decisive. What this really turns on is an objective view of the clause and of the contract as a whole. I also have a question here about early termination penalties. Yes, well, I tried to cover some of the ground in the third case study, which was to do with fixed-term contracts and the penalty for terminating early. In my view, the relevant factors which you should try and consider are, number one, does the early termination penalty apply in a blanket fashion? Is it one size fits all? Do you have to pay the same amount whether you terminate a few months early or a few years early? In my view, if you have a more sophisticated clause which is graduated, which says, for example, you pay less the later you terminate the contract, then that's more likely to be enforceable. I suppose the other factor you might want to consider is how much has each party invested in the contract? Let's say, for example, you have a 3-year fixed-term contract for the lease of some specialised equipment. If the equipment has been made in a manner which is bespoke for you and where it can't be redeployed easily, then the supplier of the equipment may very well say, we spent thousands of pounds designing this equipment and supporting it, and in fact we recruited a team just to operate it, and we invested that much time and money because we knew this was going to be a long fixed-term contract with a guaranteed minimum duration, and that's why we put in an onerous penalty for early termination. If, on the other hand, the equipment is simply something which the supplier, let's say it's a cash machine, which the supplier puts in someone's shop, and in case of early termination, the supplier can then redeploy that cash machine to any number of shops. In that case, it would be harder to justify an onerous penalty provision, in my view. I note that I've had quite a few questions come in. I'll take one more question, and then I'm afraid we might have to wrap it up. So I have a question here about parking tickets. I try to avoid parking tickets. We all try and avoid parking tickets, but here's the question. Are the wrong parking tickets that give options for early payment at 50% of penalty lawful? I think this is a question about whether parking tickets are unlawful penalties. Well, this was the other case which was joined with MacDessie, the case of Parking Eye. And in that case, every judge at every level, from County Court through to Court of Appeal and Supreme Court, all said the parking tickets are enforceable. They are not unlawful penalties. And the reason they gave was that let's go through the stages. The primary obligation is the obligation on the motorist not to overstay. Stage 2, the legitimate interest in having that obligation performed is that the landlord wants to ensure that no one is hogging parking spaces, wants to ensure that the parking spaces are for genuine customers and that there is a good turnover in the number of customers, because there is an interest in having lots of people come to shops. Stage 3, what's the penal clause? Well, you would say it's the fine, £80, £100. And step 4 is does the punishment fit the crime, so to speak? Does the penalty of £80 bear some kind of proportion to the legitimate interest in keeping the car parking spaces flowing freely? And the Supreme Court and the courts below all held that it did. It's another example of where we as lawyers can be creative when looking at the underlying interest in the obligation to perform. It's not just the immediate loss. So the landlord doesn't actually suffer a loss of £80 if someone overstays by 5 minutes. There is no genuine pre-estimate of loss involved. The way the lawyers argued the case was to say that the legitimate interest is wider and broader than simply any loss which could or could not be caused. I think I've spoken for long enough. everyone is very busy. I'm very sorry if I didn't get a chance to answer your questions, but I hope you enjoyed today's webinar. I'm very happy to help if ever you need help with your clients' cases. Please do provide feedback on the link which will be sent to you all at the end, and enjoy the rest of your day.